Hey everybody, Jennifer Schaus here. We're coming to you live today from Washington, D.C., and thank you for joining us in our webinar series covering the FAR, or the Federal Acquisition Regulations. A little bit about the series. On Wednesdays and Fridays this year, from January through July, we're covering all parts of the FAR. The series is complimentary and it is recorded. You can find our recordings over on the YouTube channel. There's no cost to subscribe to the channel, and then our PowerPoints are all posted on slideshare.net. You can log into SlideShare with your LinkedIn credentials, and again, that's a complimentary or free platform. If you're interested in sponsoring or advertising, we do have options available. And if you're looking for any of the recordings just on our website, or you want to sign up for something that we have yet to cover, you can navigate over to our website, click on the section called the FAR. Again, here you'll find the recordings as well as opportunities to sign up for upcoming presentations. We did actually cover the FAR back in 2020, so it's been 4 years. If you're anxious to get to a part that we have yet to cover, keep in mind that when you go back to 2020, some of the information might be out of date as these regulations have changed over the years. A little bit about us. We do provide consulting services for established government contractors. We work with product, service, and software companies, primarily helping them get onto the GSA schedule, as well as submit modifications, manage their schedule, the back office compliance, helping with audits, renewals, and pretty much everything and anything that goes with the GSA schedule. We also help with other contract vehicles, Library of Congress, FedLink, GSA Alliant 3, NASA SOUP, all of the others, and you'll see a slide on that in the next couple minutes. We do have a newsletter that goes out every Monday. It now reaches over 30,000 subscribers, most of which are government contractors. So if your target audience is in fact contractors and not the government, so here we're speaking to the banks, the law firms, insurance companies, payroll, HR, we do have advertising opportunities there, as well as opportunities to sponsor any of our events. We're currently running a special that will run for 13 weeks starting May 6th. It's a buy one, get one. Again, here's some stats on the newsletter. If you want to advertise, shoot us an email. We'll give you the pricing on the buy one, get one. We also wanted to bring your attention to some things that are happening up on Capitol Hill. For the current week, there's nothing scheduled, but next week, FinCEN will be over at the Rayburn in room 360, covering the Corporate Transparency Act. And then if you're selling to Department of Interior, you might want to hop over on Thursday, May 2nd to the Dirksen building, as their budget will be discussed. Our sponsored content webinars, we've got a two-part series with Carrie Palmatier from Palmatier Law, back-to-back Thursdays in June, covering SBIRs and STTRs, small business innovation research, and small business technology transfer research. So this will be a great series. Those are both 30-minute webinars. You can actually sign up for those on our website under the event section, even though they are webinars. And then with our friends over at the Eastern Michigan Apex Accelerator, I'm going to be presenting on GSA schedules. That's next month, Tuesday, May 21st. This is also complimentary. And then I'm going to be presenting June 4th, which is also a Tuesday, on some basics to marketing to the federal government. Okay, now we want to thank our webinar sponsors. Our friends over at GovEvent have the premier and really the only consolidated platform for listing events related to government and government contracting. So we want to thank them for just existing. So all of our webinars are posted there, as well as our recordings. And you've got over 600, almost 700 from us listed there. We also want to thank Tom Johnson and his team at Set Aside Alert. That's the go-to publication for contracting opportunities for small, women-owned, veteran-owned, hub-zone, and 8A firms. Visit setasidealert.com for more information. And then the Fairfax Economic Development Authority has an online calendar of events and webinars. We want to thank them for posting our events and webinars on their calendar. Over at the George Mason University in Fairfax, Virginia, you'll find the Virginia Apex Accelerator, formerly known as the PTAC. They've all rebranded and been renamed, again, Apex Accelerators. They offer free one-on-one counseling to established government contracting firms in Virginia on federal, state, and local procurement topics. If you're interested in learning more, please use the links provided to explore their services, review homework recommendations, register for live training, and find useful links to agencies and other self-directed learning. One-on-one counseling is, however, limited to eligible client companies. Appointment requests are handled in the order they were received and based on counselor availability due to high demand. Online resources and group trainings are free with no restriction on your business location. The Greater Reston Chamber of Commerce has a monthly government contracting council meeting. They had one yesterday, and then the next one is coming up on Tuesday, May 28th. But more exciting than that is their big matchmaking conference, which will be Thursday, May 2nd. So that's next week from 8 to 1 p.m. It's over at the Sheraton Reston in Virginia. We will be there. Stop by our booth to say hello. Bid speed, do you want help winning government contracts? Bid speed can help. Users can find bidding opportunities from federal, state, and local government. Additionally, you can search for teaming partners, incumbent point of contact, find expiring contracts, locate a compliance matrix, and also proposal templates. Create your login today at bidspeed.com. And BidSpeed is an official partner of the US SBA 7J Management and Technical Assistance Program. The Federal Business Council events are the ultimate engagement channel to bring government and industry together. 68% of government personnel report that they attend more than one event each year. FBC has worked with government and industry for 45 plus years to create gatherings where ideas are shared and to help government achieve its goals. This includes agency industry days, cybersecurity symposiums, tech expos, and offsite meetings. FBC provides full lifecycle meeting planning and event management. With over 5,000 meetings under their belt, FBC has the experience, systems, and personnel to make your next event exceptional. Learn more at fbcinc.com. Last but not least, GovBrew. Please check out our friends over at GovBrew. They are the most read government contracting newsletter, keeping thousands of government contracting professionals in the loop with news, updates, and opportunities in the federal contracting market, all in a fun and accessible email that only takes 5 minutes to read. It's 100% free to join. Goes out every Monday, Wednesday, and Friday at 7 a.m. and is filled with great content, event postings, webinars, and more. We encourage you to sign up at govbrew.co, or you can use the CR code you see on the screen. Okay, the reason that we're here today is to cover the FAR Part 27. Again, today's webinar is recorded, as are all of our webinars. We are lucky to have Zach Jacobson here with us today. He's going to cover, again, FAR Part 27, which is patents, data, and copyrights. Zach, I'm going to put myself on mute. Feel free to introduce yourself a little bit further if you like, and then just let me know when you're ready for your next slide.
All right, thank you very much. Good afternoon, everyone. As mentioned, my name is Zach Jacobson. I'm an attorney at the firm Seyfarth Shaw. I'm here in our Washington, D.C. office in the Government Contracts Practice Group. My practice primarily consists of representing contractors in really any manner of government contracts related disputes and litigation, your bid protests, your claim appeals, and even prime, sub, and teaming disputes. But when I'm not representing contractors in a dispute, I really focus my counseling services on issues related to something called data rights. And data rights are a big part of FAR Part 27, and so I was thrilled with the opportunity to talk about FAR Part 27 with you today. Next slide, please. So today's topics, I'm going to generally give you an overview of FAR Part 27, and we're going to be focusing on the subparts that I think are the most important and the most in-depth, and that's subpart 27.2, 27.3, and 27.4. And 27.4 in particular for government contractors is a critical part of the FAR. And what we're going to be doing is not only are we going to be walking through the rules, but I'm going to try to provide some context around the rules to the extent that we can. Now, this is a very dense and complicated subject matter, so we're probably not going to have the opportunity to really get into the level of detail that I would like to. But within the time we have, at the very least, I hope to hit the key points and at least point areas of interest for anyone that works in this area to better prepare you to navigate issues that might arise under this FAR part. So without further ado, let's get started with subpart 27.2. Oh, that's right. I added this slide in at the last minute because I realized it's hard to talk about FAR Part 27 without having a general understanding of terms that are relevant in intellectual property law. Now, this is not an intellectual property presentation, and I'm not going to be going into any sort of detail about these different concepts, but I want to make sure that we have a shared understanding of what they are so that when we're going through the FAR, everybody is sort of on the same page. For people that are very familiar with these terms, this is going to be incredibly basic. But for those of you who aren't familiar, hopefully this will give you a working rudimentary knowledge so you're able to follow along when we get to the part. So generally what we're going to be talking about when we're talking about FAR Part 27 are patents, copyrights, trade secrets, and although not on this slide, this would also apply to trademarks. So when we talk about patents, generally what we're talking about is a patent is giving the inventor or a licensee the right to exclude others from making, using, or selling the invention. So we're talking about, for example, the light bulb. And this is something to protect people that invent something new and from having any sort of economic benefit be taken away from them. It's really, think of it in terms of the right to exclude others from using your invention without your permission. We're also going to be talking about copyrights. Copyrights are a little different. We're not talking about inventions. We're talking about copyrights. We're generally talking about what we call works. Works could be really anything in a fixed medium of expression. So it could be a script to a play, or it could be source code for software. There's any number of things that could be considered subject to copyright. And this is very important in the government contract space because a lot of the information that is exchanged with the government is either going to be subject to copyright or the third category, trade secrets. So trade secrets is pretty broad, and generally it's talking about any sort of information that has commercial value by nature it being kept secret. This is like the recipe for Coca-Cola, right? If everyone knew how to make it, it would lose a lot of its value outside of its, out of its brand name because everybody would know the secret. And sometimes, something that could be subject to copyright, it's more valuable to keep it a secret because then nobody knows what it is. And so keep these terms in mind as we go through the part, because these are the types of what we generally refer to as proprietary interests that contractors have when it comes to their intellectual property and it comes to any of the intangible values in their know-how or in their processes that might be brought to the bear in performance of a government contract. Next slide, please. So what is the government trying to do here in FAR Part 27? Well, like with many parts of the FAR, the government is trying to balance a lot of different policy objectives. One of the things that stands out if you read through this part is that the government is trying to recognize and protect inventors' ability to develop commercial applications for their inventions. And that's because the government is interested from a policy matter in economic growth. It doesn't want to hoard all of the inventions that are created under performance of a government, say, research and development contract for itself. It wants companies to be able to go out there and spin off lots of commercial adaptations. I mean, if you look at the tech sector today, many of the products that are now made entirely in the commercial sector were derived from their previous version, which was developed under various forms of government contracts or government agreements. And that spurred all kinds of innovation. However, and this is hand in hand with what we talked about earlier with patents. The government still has to operate, even in the procurement context, within its existing patent regime and its existing copyright regime. And it's going to encourage its contractors and many times require that they comply with those rules. And the government is not going to accept any liability on behalf of the contractor for violating it. And finally, when you're looking at private investment and commercial products and commercial services, the government increasingly is recognizing and valuing that the commercial sector has a lot to offer and is going to be taking advantage of it through a lot of policy, based on a lot of policy preferences force the government to preference commercial products or services to the extent they meet their need, but also because oftentimes that's where the technical know-how and ability is. And increasingly, a lot of these products and services were developed by private investment. And so what the government is trying to do here is they don't want the government to assume any liability if you, contractor, are violating the intellectual property rights of some commercial product or commercial services IP holder, but they also want to protect your private investment and recognize that things that you have developed at private expense, the government does not necessarily have the same right to as it would have for something that it funded the development of with public funds. Next slide, please. So this brings us to the first of the subparts, patents and copyrights. So patents and copyrights, and the way that it's structured, I think, is a little awkward because it doesn't even talk about the patent application process. It doesn't go into a lot of detail about registering for a copyright. It jumps right into the heart of the matter, which is liability, payment of royalties, and then what happens if you want to patent something that is developed under a classified contract. They also talk about trade agreements, but it's really outside the scope of this presentation, but I wanted to mention it so you are aware for those of you that do any procurements that are subject to trade agreements or may perhaps have your supply chain be impacted by that. But that all should be laid out in your contract. Next slide, please. So patent and copyright infringement liability. So you have to remember that under the law, the exclusive remedy for someone who's patent or copyright infringement against the government is monetary damages. And so the government, because the government has the ability to authorize others to manufacture and to use inventions that may or may not be the patent holder, the government is trying to operate within this, as we mentioned earlier, this sort of patent legal regime. And so you're going to see in your contracts, to the extent that this is relevant to your procurement, that the government is going to have a lot of requirements that it's going to put on contractors. Number one, it's going to require notice if there is a claim for patent or copyright infringement, either by the contractor or if named in a complaint filed by a patent or copyright holder. It's also going to require its contractors to assist the government in litigating against those claims. And if the government determines that if the contractor somehow did something that resulted in the government being found liable for the unauthorized use or manufacture of an invention, the government could turn around and require that contractor to reimburse the government for the costs if it's dealing with a commercial product or commercial services. This is generally referred to as an indemnity clause. And so it's important to keep these in mind, that just because you're performing under a government contract, that doesn't mean that you can ignore or turn a blind eye to the patent regime. And you need to make sure that when you're performing under a government contract, that you're following the government's direction to the letter and you're communicating with the government to the extent that you run into any issues relating to using somebody else's patented invention or process. Next slide, please. And so these are the common clauses that you're going to see. And as we talked about the authorization and consent and the notice, as well as the patent indemnity, I want to just flag for you that there is a separate patent indemnity clause for construction contracts, and also that there's a clause called waiver of indemnity, because the government may decide that it is in their best interest for purposes of either competition or for other reasons to waive the indemnity, and that can be very important, especially if you're dealing with perhaps a third party who is the owner of the IP, is perhaps the original manufacturer, and the government is asking you to do something that maybe you may not be comfortable doing, such as taking their process and manufacturing the product yourself. So these are important clauses to bear in mind, and it's important that you closely look at your contract to understand where the government is placing liability. Is the government assuming it for itself, or is it going to establish some indemnity for certain situations? Next slide, please. So that was the indemnification and the liabilities. So now we're going to talk about royalties. Royalties is generally just a term for, this is how the copyright holder or other IP holder is getting paid for use of their IP. And so a lot of times the government may be dealing with a royalty payment as part of performance under the contract. Perhaps a contractor solution requires payment of royalties to a third party, or perhaps the government will require contractors to use a process or develop or data or something that involves a royalty payment to a third party. And this is why the government generally requires that you report and furnish all royalty information, and that the government will furnish to you as a prospective offeror on a government contract any royalty information, and also require that you indicate whether you are a patent owner or a licensee. And the reason for that is the government has the ability to negotiate reductions or demand a refund if it believes that any royalties are excessive or inconsistent with their rights or are otherwise improper. And so this is sort of similar to other situations where you're not really allowed to withhold information from the government. On the subject of royalties, disclosure is key. And bear in mind that the government will certainly pay, and in many cases, any contractor royalties that are required, but it will also recover royalties if it finds that either one, they were in the government's view excessive or inconsistent with the law, or if the government finds out, perhaps through an audit, that it was paying royalties that were ultimately not passed on and paid to the appropriate party, even though they were included in the contractor's fixed price. So this is just another one of those issues that you just need to be aware of its existence. And if you have a contract that deals with royalties, make sure that you have somebody on your team or you're seeking advice from someone who can help you work through these issues, because it can get complicated pretty quickly. Next slide, please. And just like with the last topic, here are the clauses that you could expect to see under the FAR. And they effectively do the things that we talked about. It's how in the contract the government is able to enact those policies. Next slide, please. So finally, the last topic for this subpart is the security requirements. And this is something that's really common if you do a lot of work in the classified space, especially if you're doing some sort of research and development work, or if you're dealing with a lot of new technologies. Because, and we don't have time today to get into the patent application process, but it's important to remember as a government contractor, if you don't remember anything else, is that you're going to have to notify the government that you're going to file a patent application. And when you're filing a patent application, you're going to have to include certain information. And if that information is classified, the government has to effectively do a classification review to determine to what extent there's a security classification that has to be attached to your patent application. That's not the end of the world if that happens. It just means that the contractor may have to transmit the application to the United States Patent Office in a different manner than it ordinarily would for your run-of-the-mill patent applications. And so there's the clause, and if you work in the classified space and you see that clause on your contract, just make sure that you don't get tripped up at that stage, because the last thing you want to do is an unauthorized disclosure. And that's what this clause is to protect everyone for, to make sure that that information remains secure and allowing you as the inventor to pursue your rights to apply for a patent. Next slide, please. So now we're moving on to the next subpart, which is the patent rights under government contracts. And as I said before, unfortunately, we just don't have enough time to get into the entire application process, but just know that inventions made in performance of work under a government contract, you are eligible to be patented, and the government is generally not in the business of doing this. What the government wants is the government just wants the ability to use whatever was developed without having to pay you the customary license fee, as you may have to pay out on the commercial market. But before we go on, it's important to talk about definitions. As you'll see in this subpart and the next subpart, definitions are very important, because while the FAR has a definition section, and we all know that every part of the FAR has its own definition section, FAR Part 27 is so complicated that each subpart has its own definition section. So it's something to bear in mind that these definitions are applicable specifically to this subpart, and that's why they're important. So we're talking about inventions made in the performance of work under a government contract. So invention, think back to the overview slide about patents. Any invention or discovery that is or may be patentable. Made actually can mean two things, and this is an area actually where people get a little confused by made. Made can mean the conception of the invention, or it can mean the first actual reduction to practice of the invention. And reduction to practice, of course, means the first time you manufacture the product, or the first time that you execute the process, or the first time you successfully operate the system under such conditions as to establish the invention is being utilized and its benefits are available to the public on reasonable terms. But that's reduction to practice is not the only method. It also made applies to the conception. So why am I harping on this? Well, because if you look at the next definition, subject invention, that's what we're talking about here. Any invention of the contractor made in the performance of work under a government contract. If during the performance of work, the inventor conceives the idea, that could be enough for the government to consider it a subject invention, which is relevant when you're talking about licensing and then the government rights to use the subject invention at a later time. Next slide, please. So what is the government policy? I mean, this kind of goes back to the beginning of the different balancing of objectives that we talked about at the outset, right? The government wants to promote the use of inventions from federally supported research. Federally supported research is not just transactional. The government's not just getting something. They also are investing in the American economy. They want to encourage wide industry participation in research and development. They want to promote competition and free enterprise, and they want to promote future research as well. They're interested in the commercialization of these inventions, and they want all of these inventions to be publicly available throughout the United States. However, they are funding the research, and so that means that they want to ensure that the government, which has no interest in ownership generally, but they have sufficient rights to use the subject inventions and protects the public against non-use or unreasonable use of the inventions. And we'll talk about that a little later when we talk about margin rights. But the government is not going to support you from patenting processes and then sitting on them. The government wants you to pursue the development and commercialization in order to get the economic growth. And of course, as with everything, the government's interested in minimizing administrative costs. Next slide, please. So the contractor right to elect title. Now, this is if you don't remember anything else about this subpart, this is the thing that's most important. Generally, after you disclose it to the government, you have the right to elect to retain title to any subject invention. Of course, there's a list of exceptions here, but typically that's not going to apply. And this again factors back into the policy objectives that we talked about, that the government wants you to invent stuff, and then the government wants you to commercialize it and have the entire public benefit from it. Next slide, please. So the government has rights too. So while the contractor has a right to patent and to own the patent of a subject invention, the government's going to have a right to license, and maybe not title, but sometimes, and we'll talk about that a little bit, but license is most common what you see, and the government expects to have at least a non-exclusive, non-transfer or revocable paid-up license to practice or have practiced for or on behalf of the United States, any subject invention throughout the world. What that means is if the government's funding the development of your subject invention, or let's just say you conceive the subject invention and the government knows you conceived the subject invention, if you create a new product, you can't turn around and charge the government a license fee for that product on a future procurement production contract, because the government's going to say, hey, wait a second, we paid for this development, so we have a right to use it, and you can't charge us for that. But in exchange, you get the title rights. Now, what can happen, although this is not common, if the contractor fails to disclose the invention, or if the contractor isn't interested in patent rights, but the government is, the government or the patent abandons their application and doesn't bother, the government can acquire title. And if it does so, then the contractor would be the one to get the granted, revocable, non-exclusive, paid up license to that subject invention. But that's not common. Typically, if you invent something and you go through the patent application process as a government contractor, you have an interest in developing that into something new. And the government supports that. However, they will vigorously defend their license rights. Next slide, please. So this is what I mentioned before, march-in rights. So this is again, not very common, but it's not unheard of. So this is a situation where either the contractor refuses to grant a license, or the contractor gets the patent but takes no steps to achieve practical application and basically just sits on it, or there's some sort of emergency or public use, like a public health emergency, for example, and the owner of the patent that has the solution is just not doing anything. The government can exercise their march-in rights, and they can either themselves develop your, let's say, your patented concept, develop it into something that can be marketed and used, or they can give it to a contractor and give a contractor a license to do it. And so, this can be pretty concerning if you have title of the patent. And so the contractor generally is provided reasonable time to present facts and show why that the agency action is inappropriate, and you do have an opportunity to appeal that. But this is something you need to be aware of. I mean, if you take the government money, there's always going to be strings attached, and one of the strings is they expect you to pursue commercialization and development of the new technology. Next slide, please. And so for patent rights, these are the FAR clauses, and they generally cover the concepts that we just talked about. Patent rights ownership by the contractor, and then patent rights ownership by the government. Next slide, please. All right, now we're into the good stuff, or for those of you that practice in the area, the stuff that we deal with on a more regular basis in government contracts, data rights, data and copyrights. This is an incredibly complicated area. And for those of you that also work in the Defense Federal Acquisition Regulation Supplement, the rules can become even more prescriptive when you're dealing with the Department of Defense. But don't be fooled. The FAR is plenty complicated as it is. And like the previous subpart, it has its own definitions. And I pulled the most important ones, which are practically all of them, onto the slides for us to talk about. So what are we talking about in this subpart? We're talking about data. Data is, imagine data is sort of in the most broad sense. Really any recorded information is going to be considered data. And so if your FAR contract is talking about data, it can be technical data, it can be computer software, it can be any information except for contract administration, incidental stuff like your cost or pricing data or things like that. But really anything else could fall into this. This is very broad, and this is why this is an area where contractors frequently need help because it applies to so many different things. And then of course the rules, are complicated. So now that's data. Now we're going to talk about a subset of data that's also pretty critical to understand. It's called form, fit, and function data. Form, fit, and function data is a subset of data that is essentially the data that the information that the government needs to configure and integrate whatever thing you're delivering into their system. So in the context of computer software, right? They can't just like take computer software and use it. The computer software is probably being integrated into a larger solution or into an existing government platform, which means they're going to need some data in order to successfully use that. And that's what this data is. And the reason that this is critical to understand is we have a definition in the FAR of what form, fit, and function data is. But you need to look at your solicitation and make sure that the solicitation doesn't specify additional data categories to fall into form, fit, and function data. And when we talk about rights, I think on the next slide that you'll see why. So let's go to the next slide, please. So these are the other terms that we really need to talk about, which is rights. Because we talked about data, now we're going to talk about rights. and you have data rights. So unlimited rights. Unlimited rights is generally what the government expects, except for a few exceptional instances. And that means that the government expects to be able to use or disclose or reproduce or prepare, distribute, or publicly display in any manner, any purpose, or permit anyone else to do so, provided it's for, these purposes or government purposes, the data that you deliver to them. So if this is something that needs, that has commercial value from being kept secret, this is a problem, right? Well, that's why we have things called limited rights and limited rights data. And so for those instances, because again, the government's trying to balance, its license to use something versus protecting the proprietary interest of the contractor who paid to develop it. Limited rights data that's when you're talking about your trade secrets, your commercial or financial confidential information or privileged information. But the key is that have been developed at private expense. And I underline that because as we talked about in the previous subpart, something that's been developed at public expense, the government is going to get unlimited rights to. And so the government is going to be very interested if you set forth a limit, if you go to set forth a limited rights notice, why they don't get unlimited rights to something. And you need to be prepared to explain to them sort of why, not only is this developed at private expense, but they may challenge you on that, and you need to be prepared to substantiate your claims. Next slide, please. And so restricted rights and restricted computer software, the FAR doesn't do the same level of bifurcation that the DFARS does, but it does recognize that computer software is a subset of data that's treated a little bit differently. And so that's why they have a separate restricted rights notice for computer software, as well as restricted computer software being additional term of art. And once again, we're talking about computer software developed at private expense, trade secret, commercial, financial, etc. Next slide, please. So those are our terms. So what's the government trying to do here? And once again, agencies, they do have a legitimate need for data in public procurement. Maybe not as broad as they always seem to advertise, but there is a legitimate need because on the one hand, government is concerned about something called vendor lock, meaning there's one company that owns the IP to a particular solution that the government needs. And as a result, they can only award contracts to that one company over and over again. If you're that company, that's great. But if you're concerned about competition and all the benefits of market competition, not just in procurement, but in terms of spurring innovation, that can be problematic. And so the agencies will aggressively try to acquire as much data as they legally can in order to level the playing field to give all competitors opportunities to use the same information. Agencies also have a tremendous amount of reporting requirements, both to Congress, to within their agency, and sometimes even to the public, that requires disclosure of certain types of data. And then, of course, they're also concerned about appropriate utilization of any publicly funded research, and they also have other programmatic requirements and acquisition needs that they need to balance. And while all that's well and good, contractors have a proprietary interest in data. And they were going back to those, those intellectual property concepts that we talked about at the beginning. Contractors need to be able to protect those interests. And the government recognizes that, or at least they should recognize that, because it's recognized in the FAR. And so that's really what data rights is. It's balancing government contractor proprietary interest against all of these agency policy objectives that favor open source. Next slide, please. Okay, so what are, so this is really the meat of it. When we're talking about data rights, what are we really talking about here? So generally, contracts that require production or furnishment or acquisition or just require delivering data. And data, remember, data is a lot. Data could be a manufacturing process. Data could be computer source code. Data could be all kinds of things. And when they require delivery of that data, the presumption is the government is getting it with unlimited rights, which means the government can use it, reproduce it, or disclose it however it sees fit, provided it's for a government purpose. And so data rights clauses are not specifying what type of data, how much of it data, or even the quality of data. It's only talking about those rights, the government's unlimited rights or the contractor's ability to restrict the government's rights in order to protect its proprietary interest in the data. And this tension is the essence of data rights. Now, if you want to know what am I supposed to deliver under the contract, well, that should be in your statement or scope of work. That should be a deliverable, a contract deliverable, and it should be very specific. And there's a whole lot of documents, a nesting doll, if you will, of descriptive documents, depending on the agency that you're working with, that talks about what exactly they mean when they say deliver this technical data package. We don't have time to get into it in this setting, but you have to know that that's in your contract, but that's not going to be in your data rights clause, because your data rights clause is, again, looking at the rights to use the data, not the data itself, or more specifically, not the deliverable itself. That will be elsewhere in your contract. Next slide, please. So as I've harped on, the government generally requires unlimited rights, except for copyrighted works, but we'll talk about why in a minute. But these are the general scenarios why they come up, why the government requires unlimited rights. First, if the data is first produced in the performance of a contract, the government's funding the production of that data, the development of that data, and much like a subject invention, to use that recent, I guess, as an analogy, the government is presumably, hey, we funded the development, so we have unlimited rights to use it. We talked about form, fit, and function data at the outset. That's going to be considered unlimited rights because, again, the government, they may have support contractors, they may have other parts of the government that need that data in order to use the solution. And then finally, of course, instructional and training materials. And finally, the great catch-all, all other data delivered, other than limited rights data or restricted computer software. So what does that mean? That means if you're delivering something that has restrictions on it, you better mark it, because the government's going to presume they have unlimited rights to use it. Next slide, please. So let's talk about limited rights data. So, what do you do if you have something, some data that's related to a contract deliverable that you don't believe the government's entitled to unlimited rights to, and you have a proprietary interest in that data because you don't want your competitors to see it, you don't want to lose your competitive edge by having it put out on the internet? Well, you withhold the data from the government. Don't deliver it. Unless the contract is telling you to deliver that data, don't deliver that data. Now, if the contract is telling you to deliver that data, I hope you disclose to the contracting officer at the outset these issues, so you could negotiate a license. But if not, at the very least, this is where the rubber meets the road. You're about to deliver something and you can't deliver it. So what can the government do? Well, if the government needs it, they can still demand that you deliver it, but you can specify, yeah, sure, we'll deliver it, but with limited rights. And so this is really important because agencies are forbidden from using limited rights data for purposes of manufacturing or disclosure of the data outside of the government, except as specifically set forth in your limited rights notice. And this is really important because if you lose this protection, then limited rights data is no different from unlimited rights data, because that's really what we're worried about. We're worried about keeping it a secret in order to maintain its value, which is derived from it not being public knowledge. Now, this doesn't mean that nobody can see it. Like I said, there's acceptable uses. You're going to have support contractors. Maybe they have a contractor who's sort of acting in an advisory capacity, who's evaluating proposals. They may have an opportunity to see it. Or perhaps there's an emergency where they have to share it. But in all those cases, there's the opportunity to at least have non-disclosure agreements or other mechanisms in place to protect the wide distribution of that data. But it's important to know that when you're talking about limited rights data, all you're doing is limiting what the government can do with it. You're not eliminating the requirement to deliver it. And so the government can either require it at the outset as a contract deliverable, or later on the contracting officer can negotiate, hey, we actually do need this data, and then you can work it out during performance. Next slide, please. Similar to limited rights data, you have restricted computer software. Again, the best thing to do if you have restricted computer software that is not identified as a deliverable under the contract, don't deliver it. Withhold it and make the government negotiate a restricted rights notice and ways to prevent wide distribution. Also know that if the restricted rights notice is not expressly stated in the contract, then the government isn't going to be bound by it. So you have to make sure that this gets adopted into the contractual arrangement with the government in order to be effective. It's also important to know that the difference between computer software and of course other types of data is, you're worried about your computer software that's proprietary effectively becoming open source, because then it'll lose its commercial value because anybody can make it. And so there's like an alternative to the clause in the FAR that specifically addresses restricted rights notices, and there's a lot more, I would say, specificity in the rules when you're talking about computer software versus data rights, data generally. And so it's important that you're paying attention, not only to what the contract deliverables are, but what types of rights that you're trying to negotiate with the government. Next slide, please. And so if the government does manage to get you to deliver restricted computer software, so what can they do? Well, it's not that it's going to be in a black box, right? It can be copied and used for the computers for which it was acquired. I've even seen in the government saying we want to use this for 10 computers and negotiating distribution of 10 computers. But they can use it for a backup computer. They can reproduce it for safekeeping. If they have other restricted software, provided that it's the same level of restrictions, they can essentially intermix them and combine them or modify them to work together. As always, the government uses a lot of support service contractors. Those support service contractors, if they have a need to know, will have access to the restricted computer software. And these rights will automatically apply. So if this is too broad, if this is too concerning, you need to negotiate different rights in the contract up front and have it specifically state that in order to protect your computer software. Because once a competitor gets a hold of the source code, I mean, you've lost the secret sauce, you've lost your Coca-Cola recipe, and you're going to be dealing with competitors that are producing identical solutions. Next slide, please. Okay, so we mentioned copyright. Copyrighted works. This is something that comes up a lot, but it isn't very controversial. Essentially, whenever you have copyrighted work, the important thing to remember is the copyright marking has to be affixed to it. And the copyright marking basically identifies who the owner is and identifies the purposes for which it can be distributed. And so how copywriting works with a government contract depends on when the data, or remember the work, but in this case, in this part of the subpart, in this subpart, we're talking about data, where the data was first produced, whether in performance of a contract or not in performance of the contract. So if you produce data in performance of the contract and you want to copyright that data, perhaps it's a software solution, right? You have to get permission from the contracting officer first prior to asserting your rights through a patent application process. You have to do a written request. You have to identify the data. You have to identify the intended dissemination. This is common. This is also very common with data resulting from research or data resulting from studies in different types of R&D contracts. So the contracting officer generally should grant this request. It's very routine, but there might be a few instances when it won't. And so now, once it's granted, that doesn't mean that you can now turn around and start charging the government for use of the work, because remember, just like with anything else, if the government funded the development, the government gets unlimited rights to use it. And so that's something that the contractor grants, by definition of developing data that it wants to copyright under a government contract, a paid up, non-exclusive, irrevocable, worldwide license to produce prepared derivative works, distribute to the public. Other than computer software, remember, computer software is a little different, so they can't distribute computer software to the public, but they can publicly display on behalf of the government any of the data produced in performance of the contract. So what does this get you really? Well, I mean, when this does give you the ability, this is just dealing with the government. If you're dealing with the commercial side, especially if you have a commercial solution you want to incorporate this into, you now have copyright protection. And that allows you to charge royalties to your commercial, in the commercial sector, that you may not be able to in the government sector. So it's still something you definitely want to do. Just bear in mind, you can't use it to then turn around and charge the government for use of the work. Next slide, please. Which then, you know, what about, okay, well, what about data that wasn't produced in performance of the contract? But you know, maybe you need to deliver it. Well, just like with any other copyrighted work, you know, you can't put on a school play without getting the rights to use the script. And it's the same thing here. You know, you have to acquire a copyright license for the data, unless the government directs you to do otherwise, because the government, due to any other circumstances, may tell you to do it. But that's fine, as long as you get that in writing and protect you from any liability. But generally, you have to acquire a copyright license for the government, or if you're the copyright holder, you have to grant a license to the government in order to deliver it. And then, no matter what, always affix the applicable copyright notice. And these notices here just sort of distinguish whether it's government sponsorship or not. Because if you fail to do this, you know, even if it's just a simple mistake of just not marking it, you could result in data being treated as unlimited rights data, which could open you up to liability if you're not the copyright holder, or it could at the very least result in something being distributed without the appropriate restriction of the copyright, and somebody else could take it and repurpose it, not knowing that there's a copyright. Next slide, please. So markings. This is very important when you're dealing with data rights. You know, how does the government know that something you're delivered, they only have limited rights to use or restricted rights to use? How do they know that something is copyrighted? Well, it's because it's marked. And this is where a lot of disputes happen, because what will happen is the government will get something if they don't think the marking is authorized because it's not in the contract. They can return the data to you, or they can cancel and ignore it. So if they cancel or ignore it, this triggers a pretty intensive process where the government will turn to the contractor and request justification to substantiate the marking. So if you mark something as restricted computer software, the government, if the government doesn't believe it's authorized to have that marking, they can request that you substantiate it. You got 60 days. If you don't respond in time, the government can cancel or ignore it. And then if you do respond, the government doesn't have to agree. The government can issue effectively a contracting officer's final decision as to the authorization of the markings. And if that happens, now you have 90 days. You have 90 days to file suit in a court of competent jurisdiction. So you effectively have 90 days to go to the Board of Contract Appeals or to go to the Court of Federal Claims, or else after those 90 days, the government is going to cancel or ignore the markings. And that is not good. So this is, out of anything in data rights, you know, remember the data means everything, and remember the different types of rights, meaning limited versus unlimited. But then remember markings, because markings is where most of the issues that we encounter, at least in our practice, tend to stem from, because it's the first time that the government realizes there wasn't a meeting of the minds on its ability to use certain data. Next slide, please. Omitted and incorrect marking. Oh gosh, this is another great one. So if you deliver something and you don't mark it, the government will has the ability to presume that it's been delivered with unlimited rights, and the government will, of course, assumes no liability. So this is why you need to be on top of your data packages and different technical data deliverables, because if you make a mistake, I mean, it may not even be your data, but you could be opening yourself up to liability from the person who owns the proprietary interest in that data. And so the FAR provides you a 6-month period or longer for good cause shown to request permission to affix the markings, which the contractor has to be pretty specific, and the government will generally approve, but will charge the contractor for the expense. And so again, if you don't remember much from this section of the presentation, please remember to make sure that your markings are correct on any data you're delivering to the government. Next slide, please. So we have we're almost running out of time here, so I want to make sure that we harp on a couple of special rules that are in the FAR for different types of data that's unique. And a big one that comes up really all the time these days is commercial computer software. So unlike software developed at private expense for the government or software developed at public expense for the government, commercial computer software, you're talking about software that, yeah, was developed presumably at private expense, but it wasn't developed for the government. It's just a commercial solution that's out there on the marketplace. And so you don't follow the same sort of format in terms of your restricted rights notice that you would follow for a non-commercial but still privately funded solution. And so generally what the government is expecting is licenses customarily provided to the public to the extent that it's consistent with federal law, which means that whatever license you provide to the public probably is not going to be consistent with federal law. And so there's going to be a lot of back and forth and negotiating to make sure that your commercial computer software is protected, but the government is still getting what it needs. And there is a commercial computer software license clause in the FAR that is helpful, but it probably is not going to be sufficient. And this is where things like end-use licensing agreements come into play, and commercial licenses for government customers becomes very important. Now, of course, this is going to be different if you're a GSA schedule contractor. There's probably going to be other requirements based on what schedule you're on and the type of business that you are that might apply. Next slide, please. I'll just briefly, harp on this, especially with the latest decision out of the Federal Circuit dealing with the AVU Technologies end use license agreement. These licenses can be incorporated into the contract, and unless they're inconsistent with the contract terms, they can apply. And so you do have the ability potentially to enforce that agreement against the government user, even through a third-party reseller. So these license agreements, I can't emphasize enough their importance. And the same thing that I tell our clients all the time is that, as much as you want a simple one-size-fits-all solution, you really need to be careful when you're looking at the types of government customers and the uses that they're envisioning, that your end-use license agreement is going to cover all of the potential pitfalls that your government customer could inadvertently drag you into. And if you're dealing with a reseller, as most in this space are, you might not even know who they're selling to. And so you just have to really be prepared for anything. And that's why it's very important that you work with somebody who's familiar with the space and has the expertise to help guide you to an effective solution. Next slide, please. So there could be additional data requirements. This is very, when you have a contract for something that's going to generate a lot of data and it's experimental or it's really just impossible to ascertain at the outset, what the data requirements are going to be. This is essentially a clause that allows the contracting officer to later order additional data and use the performance of the contracts once they become known. And you should see it in your solicitation, and it's primarily for experimental, developmental, or research work. Next slide, please. And then, of course, successful proposals. Sometimes the government will require you to include data in your proposal. And so just like with any other data delivery, you need to specifically identify any sort of data that needs to be excluded from the grant of unlimited rights, because the presumption, if you're handing that data over to the government in your proposal, is that the government has unlimited rights to use it. And so if there's anything proprietary, you need to be able to identify that for the government at the outset. And again, that's why it's very important that you work with somebody who knows this space, because you could inadvertently turn over the keys to the kingdom and not even get awarded the contract. So this is why I wanted to flag this particular part of the FAR. Next slide, please. So finally, so for the FAR provisions and clauses for data rights, these are the ones that we talked about today. I also flagged the SBIR contract data rights clause. We didn't have time to talk about it today, but this is also, if you're in this program, you're going to have your own set of rules and your own clause. And it's something that you should pay attention to if this applies to you. Some of the rules that we talked about may generally apply, but you also may have some other things that you need to worry about. Next slide, please. All right, that's the end of our presentation today. Thank you very much for your attention as we talked about FAR Part 27.
Zach, that was a great presentation. Really appreciate the time that you took to put together the great content. I know a couple questions came in. Again, we don't take Q&A in this series, so please contact Zach directly. You've got his email address right here. You can send your questions to him there. He's also on LinkedIn. And again, thanks everybody who joined us. Thanks, Zach, for a great presentation. We'll have the recording up on our YouTube channel probably within the next few hours. If you subscribe to our channel, it doesn't cost you anything. Leave us a comment or like any of our videos. And again, thanks for joining us, and thanks, Zach, for a great presentation. We'll see you on Friday when we cover FAR Part 28.